Students Affairs, Faculty of Law, Universitas Diponegoro, to the Honorable Guest Lecturer, Prof. Hossein Esmaili, LLB, LLM, and PhD. Before we start, we will hear speech from Dr. Trilaksmi Indraswari, SHM, as the Vice Dean for the Academic and Students Affairs. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Honorable Associate Professor Dr. Hossein Esmaili, LLB, LLM, PhD, from College of Business, Government and Law, Flinders University. All the participants, good morning. First of all, let us thank to Allah Subhanahu wa Ta'ala who has been give us blessings so we can join the visiting lecture today. I deeply honored to welcome Associate Professor Dr. Hossein Esmaili from Flinders University. Welcome, Prof, to our Faculty of Law, even in virtual. The theme of visiting lecture today, offshore oil and gas exploration and exploitation and the law of the sea. I do hope with this visiting lecture will be improve our knowledge, give mutual beneficial and significant implication to our education. It is honor for the Faculty of Law, Universitas Diponegoro, to maintain a good relationship between Flinders University and Faculty of Law, Universitas Diponegoro. We do hope the collaboration between Flinders University and Faculty of Law, Universitas Diponegoro can be maintained in the future. In addition, I would like to express my gratitude and thank to Associate Professor Dr. Hossein Esmaili, LLB, LLM, PhD, for joining the visiting lecture, and for all the participants enjoy the visiting lecture. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Mrs. Trilaksmi, for the opening speech. A very warm welcome we bid to all the participants, Faculty of Law students, Universitas Diponegoro. I would like to express our heartfelt gratitude for your presence at this memorable occasions. It is indeed a pleasure to have you all today. And thank God for his blessing so that this morning we could gather here virtually in this general lecture. Before we begin this agenda, please allow me to read the rundown of sessions for this morning. From 10 to 12, we have Mr. Hossein Esmaili, LLB, LLM, PhD, from Faculty of Law, College of Business, Government and Law, Flinders University, with the theme Offshore Oil and Gas Explorations and Exploitations and the Law of the Sea. From 12 to 1, we have break. And 1 to 3, we have Law Student Bonding with UKMF, ALSA, LC Undip, and Pseudo. Before we jump to the next agenda, let me read the CV for our moderator today. Place, date of birth, Lampung, August 18, 1991. With a bachelor degree, Faculty of Law, Universitas Diponegoro. Master degree, Faculty of Law, Universitas Diponegoro. Mrs. Anggita, the time and place is yours.
Thank you very much, Gavi, as our host for today. Good morning and good afternoon, ladies and gentlemen, the honorable distinguished guest lecturer, fellow students, and all of the participants. First of all, I would like to welcome to all of you to this general lecture about offshore oil and gas exploration and exploitations and the law of the sea. It is such an interesting topic that we will discuss for today. My name is Anggita Duramya Lumaraja. I am a lecturer in law, Faculties of Law, Universitas Diponegoro. It is my pleasure to be a moderator for this general lecture on offshore oil and gas exploration and exploitation and the law of the sea. Ladies and gentlemen, before we start the general lecture, and in order to avoid any disturbances during the presentation later, I would like to ask you to mute your microphone. So please notice your microphone button on the mute mode. And there are several pieces of information that I would like to give to you before we start the lecture. First, this general lecture will take place from 10 until 11:30 a.m. in Semarang time, or 1:30 until 3 p.m. in Adelaide time. So our guest lecturer will deliver his lecture maximum in 60 minutes and will be followed by questions and answer sessions for 30 minutes. Second, the participants are allowed to write down their questions in chat column of this Zoom meeting sidebar. Please ask your question briefly and clearly with the appropriate words. And don't forget, please make sure your questions are relevant with the topic of this general lecture. Also, we welcome your opinions and arguments on several issues related with this topic of this lecture. Third, the question and answer session will be opened by moderator right after our guest lecturer finish his presentations. In this question and answer session, moderator will choose several questions from the chat column and will read them for the guest lecturer. The moderator will also give a chance to the participants whether the participants want to ask the questions directly to the guest lecturer. Please raise hand by pressing the raise hand button in your Zoom meeting menu bar after the moderator opened up the floor to give you an opportunity to ask the question directly. Ladies and gentlemen, before the presentation begins, may I briefly introduce to you our guest lecturer for today. His name is Associate Professor Hussein Esmaili, LLB, MA, LLM, PhD. He's Associate Professor from College of Business, Government and Law, Flinders University, Adelaide, Australia. Dr. Hussein teaches international law, real property law, trust, law of the sea, energy, and environmental security. He joined Flinders University in 2005 after 7 years of teaching at UNSW, the University of New England and Western Sydney University. His current research interests include Australian perspectives on international and comparative law, particularly with regards to global energy, resources, and the environment, as well as Islamic and Middle Eastern law. Dr. Hossein has authored, co-authored, and edited 5 scholarly books, including The Legal Regime of Offshore Address Oil Rigs in International Law. It is published by Ashgate Publisher in 2001. And The Boundaries of Australia Property Law. It is published by Cambridge University Press in 2016. He has published it in leading international law journals worldwide. He has been a co-rapporteur of a committee of the International Law Associations since 2011 and serves on the editorial boards of a number of law journals in Australia, Asia, and Europe. Ladies and gentlemen, without waiting any longer, I would like to welcome our guest lecturer to begin the presentation. Dr. Hossein Esmaili, the floor is yours.
Okay, thank you very much. It is a pleasure to talk to Indonesian scholars, academics, lawyers, students. I'm very pleased for that. Before I start, can you see my PowerPoint notes?
Yes, it has been showed in our monitor.
So, great. Now, the topic of my lecture or talk is, as you mentioned, is offshore oil and gas exploration and exploitation and the law of the sea. this is an area that I have been researching, teaching, exploring for over 25 years. Now, I have published in this area, and also I have supervised students. Interestingly, one of my students which I supervised on this area, like the area was regulating oil and gas operation in Indonesian waters, was an Indonesian student who is now, I think, the first secretary of the permanent mission of Indonesia at the UN in New York. So I do have some connections with Indonesia. I have been traveling because I'm an international lawyer. Excuse me. I've been traveling around the world, particularly in your area, our area, the Pacific region, South Pacific region. Unfortunately, not to Indonesia. And I hope to visit Indonesia one day, but it is a great pleasure to talk today to Indonesian legal community. As I said, I have taught Indonesian students. I have had assistances, research assistances from Indonesia, and I have published articles and books with Indonesian legal academics in Australia. So it is a great pleasure to be here, and thank you very much for the opportunity to talk about offshore oil production under international law of the sea today. Now, introduction. What I am going to do, and let me write down my time that I know how long I have to talk. So it's now 1:47 here. Now, what I'm going to talk today is about the legal regime of offshore oil production. Oil production, gas production from the sea, from the ocean, from the bottom of the ocean, of course, seabed area. Now, this is very important for Australia, as well as for Indonesia and for many other countries. This is what I'm going to do this afternoon or this morning, your time. Some discussion of offshore minerals, some statistics updating you on global offshore oil production, production of oil gas from sea bed areas around the world. Then getting to the law of the sea and offshore minerals. What is the position of the law of the sea? Now, legal principles applicable to offshore oil and gas production mainly is in the law of the sea convention, the 1982 law of the sea convention, which is one of the most comprehensive international treaties to which Australia is a party, as well as Indonesia. So I will go through the provisions of the law of the sea and some other international treaties. I may refer to international customary law as well. Excuse me. And then look at other legal principles of offshore oil production. There are many issues around offshore oil production. These are relating to the environment, security, conflict with other resources of the sea, and so on. But I will particularly emphasize on environmental issues of offshore oil and gas production. At the end, I would discuss briefly the future perspectives on offshore oil production. Okay, let's start with this note, PowerPoint note. And I obtained this photo easily today. However, excuse me, 25 years ago, when I was doing research on the law of the sea and oil production, as well as offshore oil installations, I remember to get a photo like this, I had to go to the Faculty of Engineering at University of New South Wales in Sydney to get a photo. But fortunately, by the advance of technology, I easily could get this photo this morning. And this is another photo showing how offshore oil rig, from point of view of technology, just for preparing you to go through discussion of legal principles, how offshore oil rig operating at sea to get oil and gas out of the sea. So there are different types of oil installations which are nowadays which are used for oil production, offshore oil production. Okay, let's start with some introductory background. Yeah? Okay, now humans are moving to the ocean, including to the seabed areas for food. They have been doing that for thousands of years. You know it very well in Indonesia, and we know it here in Australia or other parts of the world. Fishing is an important source of food for humans. Now, for minerals also, humans have started already, like offshore oil production started from 60s, 70s. In 1990s, like 30 years ago, around 5 to 10% of oil and gas was produced from offshore resources, from the ocean or the sea, continental shelf of the sea. And this is now increasing. However, in recent years and soon in future, in the next few decades, humans may go to the sea for shelter, for floating cities, for living somewhere, and definitely for minerals, as well as for something else that you may be surprised, for fresh water, which I refer to in a moment. Okay, so humans have exhausted a large part of onshore resources, land resources, and now they are moving to the sea. And oil, gas, other minerals, food are some example of resources that humans are looking at the sea, including freshwater resources under the seabed area. And beside oil, now there have been some mining activities around Australia, PNG, in the area, in the Pacific area, for exploration and exploitation of other minerals rather than oil and gas, like, for example, polymetallic nodules, and so on. And the last one is freshwater, which I refer to. Scientists at Flinders University here at Faculty of Science in 2014 discovered that there are a significant amount of fresh water, as much as human being has used water for the last 100 years, like fresh water that we have used for the last 100 years can be found under the oceans. And I presented a paper in Japan in 2004 specifically on fresh water under the oceans. However, I am not going to talk about it, although I refer to those issues. So this is the background to what I am going to talk. Now, let's look at some statistics. Global offshore and onshore oil production from 2005 to 2025. Now, as I mentioned, when I started to work in this area, research in this area, 90% of world oil and gas was produced from onshore resources, from land resources, particularly, for example, in the Middle East, in Saudi Arabia, in United States, in Europe, everywhere else. However, the amount of offshore oil production, oil and gas production has increased. As you can see here, by 2005, it was 32% of the world production. So from 10% in 1990. So about 10 years, it was tripled. Then slightly it was reduced, and currently, in 2020, nearly 30%, 1/3 of world oil and gas production is from offshore resources, from the sea resources, from the continental shelf, mainly of the sea. Now, this is about the whole world generally. However, countries like Australia and Indonesia and some other countries, they produce more oil and gas from offshore resources. For example, in Australia, 90% of Australian natural gas is produced from offshore resources. So look at the next slide. This is about global gas production, 2018, 2 years ago. As you can see, Indonesia, I can see that Indonesia is here as a country which produce produce gas. But as you can see, Russia, United States, Iran, China, Qatar are the major producers of natural gas. However, Australia is a exporter of natural gas, as well as I can see Indonesia also is an exporter of natural gas. But I know both Australia and Indonesia also import gas. We live in a free world. Now, this is another graph here, which shows world offshore crude oil production from 1940 to 2010. So as you can see, it started offshore oil around 1940s, 50, 60 probably. And then by, let's say, 2000, it went up and up. It was from shallow waters and then to deeper waters even. As we get close to the high seas, the amount of offshore oil is increasing. This is Australia's liquid natural gas export in 2013, and we export to Japan, China, Taiwan, Korea, and Middle East, and some other countries. Okay, so that was some statistics about offshore oil production. So offshore oil production is important. 30%, almost 1/3 of world oil and gas is produced from offshore resources, from sea and ocean resources. It is like for the next 50 years, oil and gas will be sources of energy, and they are important. Now, also offshore oil and gas production at the sea, at the ocean, creates more legal issues, more international legal issues than production of oil and gas from onshore resources. From onshore resources, like in Indonesia or in Australia, where somewhere in Australian desert or in other countries, when oil and gas is produced, there are not much international legal issues, and probably not the law of the sea relevance, except if the oil is transported somewhere else. Whereas production of offshore oil and gas is subject of international law, particularly international law of the sea, and particularly in certain areas when there are conflicts like the South China Sea or the Persian Gulf or in Timur Gap area between Australia and Indonesia. So there are transboundary international legal issues relating to offshore oil production. Now, here this slide is about offshore groundwater, which I just referred to. A review paper published in Nature 2014 by a number of my colleagues here at the Faculty of Science at Flinders University. Through an extensive research, they discovered that there are significant amount of fresh water under the oceans in areas close to Australia and Indonesia. You can see the areas that those resources of water, fresh water, which has 10 times less salt than the seawater. And these are basins close to Australia, close to Indonesia, close to the United States, Europe, and other parts of the world. And it is huge. So that might be a source for humans to go and extract water in future. However, as I said, we are talking, or I am going to talk about offshore oil and gas production, not fresh water extraction from the sea. Okay, so as I said, offshore oil and gas, offshore carbon hydro resources production, exploration, exploitation is regulated by the law of the sea and by some other international treaties. We do have other international treaties which may be relevant, international treaties in relation to protection of the marine environment, for example. There may be international treaties relating to fisheries, shipping, and other international maritime issues which may be relevant to offshore oil and gas production. However, the basic principles, the major principles of international law in relation to offshore oil and gas production are embedded, included in the Law of the Sea Convention, 1982 Law of the Sea Convention, which is probably the most important or one of the most important international treaties. It has nearly 170 countries parties to this treaty, and it has been here since 1982, which means nearly 40 years operating, and countries more or less adhere to principles of the law of the sea. Also, before 1982, we did have a number of international conventions, treaties in relation to the law of the sea, which regulated the sea. Also, as you may know, particularly those of you who are international lawyers or interested in international law, you know that the law of the sea, navigation, freedom of the seas, beside the law of the war, are two very classic, traditional, old areas of international law. Therefore, law of the sea convention is important, is an important treaty, and it regulates extensively production of oil and gas from offshore resources, as well as seabed mining in different areas of the sea. Okay, the law of the sea, as I said, has got 168 parties, is probably the most comprehensive international treaty, and came into force in 1994, but of course it was adopted in 1982. And before it was adopted, There were other international treaties. There have been significant amount of literatures, hundreds of books, articles, PhDs, research grants in law, in science, policies, international relations, political science, and other areas in relation to the Law of the Sea Convention. Even before the Law of the Sea was adopted, like in 1982, Professor O'Connell, Daniel O'Connell, who was professor of international law at Cambridge University, wrote a book on law of the sea, but he died before 1982, before the book was published. And then later, Professor Ivan Shearer, who again was from Adelaide, who was my colleague, edited that book. What I'm saying is that even before the Law of the Sea Convention came into existence, that was adopted, scholars started to write about the law of the sea. So it is an extensive area of legal scholarship. Now, these are parties to the Law of the Sea Convention. Some surprises, but also some important issues. Now, those countries like Australia, almost every country in this area are parties to the convention, including Indonesia, Malaysia, China, New Zealand. However, there are a couple of, as you can see, notable countries which are not parties. One is the United States. Now, the United States participated in drafting the article and pushed for an agreement, 1994 agreement to Part 11 of the Law of the Sea Convention, which I talked about it briefly, but they did not ratify. The US is not a party to the Law of the Sea Convention. However, they argue, or it is argued, that most principles, provisions of the Law of the Sea Convention are now customary international law. That means they are binding on all countries and the United States in a de facto status, like they are, or they have stated that they are following the law of the sea, and many or most provisions of the law of the sea are binding for the United States, but there are a few other former Soviet Union countries who haven't ratified, and there are countries like, for example, Algeria, Afghanistan, Iran, Sudan, who have signed the treaty but have not ratified the Law of the Sea Convention, but they also participate in relevant conferences of parties to the Law of the Sea and so on. So this is the status, the current status of parties to the Law of the Sea Convention. Okay, the Law of the Sea regulates the use of oceans, regulates marine resources, living resources, fish, whale, and non-living resources, oil, gas, other minerals. It also regulates shipping and many other maritime issues, building artificial islands. Different uses of the sea are regulated by the Law of the Sea Convention. Now, ocean mining or production of minerals from the ocean, production of oil and gas from the ocean is also regulated by the Law of the Sea, particularly the ocean mining under the high seas is also regulated by the Law of the Sea and by International Seabed Authority, which is a small organization, which is an important organization, but it is a small, like for 2020 or 2019, they had about 17 million budget, which is not great or big budget, but still is an organization which regulates deep sea mining at high sea, which I'll explain in a moment. The International Seabed Authority has issued 30 exploratory permits for mineral companies in the Pacific and Indian Oceans, for example, and there are more demands for deep sea mining, particularly at the high seas. Now, I'll get to that one in a moment. Now, this is where I will be talking more about the Law of the Sea Convention and its regulations with respect to offshore oil and gas production, exploration and exploitation. So you may want to take a deep breath and be ready to get into details of the legal principles of the law of the sea in relation to oil and gas production. Now, as you can see here, I'm sure many of you are international lawyers or international law academics or students who are interested in international law, particularly the law of the sea. And you know that according to the law of the sea, the 1982 law of the sea convention and other treaties before that, the sea, the ocean, is divided into different maritime zones, whether it's close to Australia or Indonesia or anywhere else. Although, of course, Indonesia is an archipelagic state, it's an archipelago, there is different regime in relation to different maritime zones, but very similar to any other country. But of course, sea and its resources for an archipelagic state like Indonesia are more important than many other states. Okay, so maritime zones, according to the law of the sea, are these territorial sea, exclusive economic zone, as well as a contiguous zone, the high seas. So these are different maritime zones. And before territorial sea, if you can see a little bit of water here, which is internal waters. So we have land is here, internal waters, then territorial sea, contiguous zone, exclusive economic zone, and the high seas. Now, exploring and exploiting for oil, gas, and other minerals and other resources is subject of different regimes according to the law of the sea convention in different maritime zones. And I try to discuss it here briefly how it differs. Now, obviously land, you know that very well, in international law since 1967, a resolution of the General Assembly of the United Nations recognized sovereignty of states over their natural resources. So there is no dispute about the land, and it is clear, and countries, every country, whether it's Australia, whether it's Indonesia, China, or any other country, small or big, they have sovereign rights over their natural resources, living resources or non-living resources onshore. When you come to the sea, it's slightly different. Now, in the territorial sea is more or less very similar to the land in terms of jurisdiction and sovereignty. That means Australia has sovereignty over its territorial sea, as well as Indonesia and China and Fiji and other countries. Every country has sovereignty over their territorial sea, and this is a principle of customary international law that has been practiced for hundreds of years, and now particularly the breadth of the territorial sea was recognized as 12 nautical miles by the law of the Sea Convention. Now, 12 nautical miles, each nautical mile is 1.8 kilometers. So 12 nautical miles is about 22 kilometers. So from the coastline of every state, which we call it the baseline, where the sea and the land touch, for about 22 kilometers, the coastal state has sovereign rights and jurisdiction for mineral resources, fishing, navigation, and everything else, with the exception of innocent passage, which I'm not going to discuss innocent passage, but in the territorial sea under certain conditions, vessels of other countries may pass through. That's it. Any other regulation in the area, jurisdiction, is subject of the law and sovereignty of the coastal state. Now, then we have contiguous zone, which is another 20 nautical mile, where the coastal state can regulate. Then we have the exclusive economic zone, which again, this was more or less established since 1982, and it is now recognized by customary international law and has been claimed by almost all the states who have coastal waters, including Indonesia, United States, although the US is not party to the law of the Sea Convention, Australia, and other countries. Now, for 200 nautical miles from the coast, states have not sovereignty, so exclusive economic zone is not part of the territory of a state, 200 nautical miles, which means around 350 kilometers, roughly. However, the coastal state has exclusive jurisdiction and has rights and sovereignty over natural resources of the area. Fish, other resources, whales, for example, marine mammals, biodiversity, if they use for resources, although they are also regulated by other international treaties, and also oil and gas for 200 nautical miles. Now, something that is very important, and I'm sure international law students know very well, is that these waters are international waters. Their status is like the high seas. It means they open to everyone. Navigation in this area is free. No country can have sovereignty over these waters, are free, freedom of the sea, part of the high seas. However, resources, whether fish in the water or other resources like oil, gas, minerals, probably fresh water, and anything else in this area are subject of law and rights of the coastal state. Excuse me. Okay, now, so we have the territorial sea and the exclusive economic zone, and then we do have something else, which was, of course, established, came to existence in international law since 1960s, is the continental shelf. Now, the continental shelf is the extension of the land into the sea. And it can be 200 nautical miles, or it can be more than 200 nautical miles, or it can be less than 200 nautical miles. Now, again, the coastal state, like Australia, like Indonesia, like United States, like any other country, has exclusive rights in relation to resources of the continental shelf. And for your information, and probably you know that most of those oil and gas and mineral production, which is 30% of the world oil and gas production now offshore, comes from continental shelf, the continental shelf of Australia or Indonesia or Saudi Arabia or European countries or United States, all other countries. All countries who produce oil and gas, mainly they produce at the moment from the continental shelf. However, as technology is advancing, it is possible now for countries or for companies to move a bit further to the international seabed area. As I said, there are now 30 licenses issued to companies from different countries to explore and possibly exploit some mineral resources from the high seas seabed area. Okay, so territorial sea, exclusive economic zone, and the continental shelf. Any resources here, living resources or non-living resources, are under control, sovereignty, and jurisdiction of the coastal state. And the law of the sea regulates those resources. Therefore, the coastal state can erect artificial islands, oil platforms, oil rigs, oil installation, gas installations, here, of course, at territorial sea, at exclusive economic zone, and even at the high seas, if the continental shelf extends more than or beyond the exclusive economic zone, however, require some kind of permission from the Commission on Limit of Continental Shelf, which is part of the law of the sea, established by law of the sea. So that's the legal status of ownership of minerals at sea, offshore minerals. The coastal state, like for example Indonesia or Australia, has sovereign rights in relation to resources of the sea from the baseline, territorial sea, exclusive economic zone, and the continental shelf, but not the seabed area, international seabed area, under the high seas. That area is regulated by the law of the sea, and there is an organization which regulates the area. Let's go further on, and I'll refer to that in a moment. Okay, so the law of the sea convention in the exclusive economic zone, which it's here, regulates sovereign rights for purpose of exploring and exploiting, conserving and management of the natural resources, whether living or non-living resources of the seabed area of the exclusive economic zone. Article 60 of the Law of the Sea Convention provides that artificial islands, installations, and structures in the exclusive economic zone can be erected by the coastal state. Then in the continental shelf, similar provisions, the coastal state exercises over the continental shelf sovereign rights for purpose of exploring it and exploiting its natural resources. Article 81 of the Law of the Sea Convention provides that the coastal state shall have the exclusive right to authorize and regulate drilling in the continental shelf by its companies or by other companies or by foreign countries, whatever. And then we have the area, which is this one, the area that is not under jurisdiction of any country. It's the high seas. It's open to everyone. It has been open to everyone for hundreds of years, since Hugo Grotius of the Netherlands, Dutch, legal scholar, published a book, which I have a copy here, in 17th century, The Freedoms of the Seas. And since then, that area has been free to all countries and still is the case. However, Article 136 of the Law of the Sea Convention provides that the area and its resources are the common heritage of humankind. They belong to everyone. That was agreed in 1982 and still is the case. And that was probably one of the reasons that the United States and major industrial countries were not ready to be party to the law of the sea until when in 1994 an agreement to Part 11 was concluded, and then they joined, and the Law of the Sea Convention came into force in 1994. There was some changes to the provisions of the Law of the Sea Convention, but still the resources of the area belong to no one. However, there is an organization called the Authority, which is established by the Law of the Sea Convention under Articles 156 to 175. The Authority has the power to issue licenses to companies for joint venture operation of resources of the area. Okay, now that was the legal regime of offshore oil and gas production under the Law of the Sea Convention. And now let's look at legal issues. What are the international legal issues in relation to offshore oil and gas production? One is the Law of the Sea issues, which I briefly mentioned. I mentioned who owns the resources, who has jurisdiction over the resources, who can establish artificial islands and installations for purpose of exploring for an exploitation of resources. Then there are also environmental issues. Marine environment is very important. It's very important in terms of climate change. It's very important in terms of biodiversity. It's important for our future, for our planet, and obviously producing oil and gas from offshore resources may create significant pollution issues. Therefore, the marine environment, protection of the marine environment, environmental issues relating to oil and gas production are important, which I briefly touch upon today. Then security issues are also important. Protecting oil installations in wars, sometimes those installations are subject of military attacks, and that happened in the Persian Gulf, and there is a case, there was a case before International Court of Justice known as Oil Platform case between the United States and Iran, where the United States attacked an Iranian oil installation in the Persian Gulf. So it is an issue in international law, and security of oil platforms is important. There might be piracy issues and other issues. The other issue, legal issue, international legal issue in relation to offshore oil production is conflict with other uses of the sea. So, as you know, navigation is very important. Most goods and products that we use in Australia, or you probably consume in Indonesia or anywhere else, they are transported by the sea. So navigation is important. Sea is used for military purposes. The sea is used for fishing and other economic reasons, for shelter, establishing artificial islands, and so on. There may be conflicts with with oil and gas production. So that's another important area of the law of the sea and international law in relation to offshore oil and gas production. And there are also overlapping issues of overlapping oil and gas resources, and that was an issue between Australia and Indonesia, and now between Australia and Timor-Leste, which there is a 2018 agreement to settle the dispute or to delimitate the boundaries, maritime boundaries, and Australia and Indonesia has a delimitation agreement, as probably you may know, as well as also managing the use of shared resources. And it's subject of conflicts, like, for example, one important issue in the South China Sea is about oil resources which are there and overlapping of the boundaries, the exclusive economic zone and other maritime zones with each other, given that China has claims and other countries have claims, and China is building artificial islands and so on. Okay, now out of those issues, obviously, I'm not going to talk about everything. I have published about the security issues of oil rigs. I have published about conflict with different uses of the sea, and environmental issues is the area that I briefly go through and explain it to you. Now, there could be many environmental issues, particularly accidental pollution, operational pollution, and disposal and decommissioning of offshore oil and gas installations. Now, land-based sources of pollution comes from dumping at sea, for example, comes from shipping, international shipping, the carriage of oil, gas, and other materials at sea, as well as accidental pollution and operational pollution. Now, you may be familiar with two important accidents in recent years. These two. One was deep water horizon oil rig, Gulf of Mexico, 2010. Barack Obama was president of the United States, and the issue was in the news. And the other one was Montara oil rig, 2009, where that happened. That accident happened in an area between Australia and Indonesia. And both are important. None of them went to international courts. Like there was no international litigation, but there was extensive other litigations in relation to these issues. Now, let me explain a little bit of deep water horizon oil rig explosion in the Gulf of Mexico. That happened in 2010, and it was a major offshore oil accident, very major. But what is interesting from my perspective as an international lawyer, as an international law academic, is that this was probably the most litigated case in the United States history, legal history. It was subject of international law, law of the sea, federal law, state law, customary international law, criminal law, civil law, private international law, and public international law. Extensive litigation covered by media, so important. And finally, it was settled. Like it was settled when British Petroleum, BP, paid $20 billion for settlement. And that was, $20 billion for a company is huge. And there was more and more litigation in relation to that issue. So that may happen anywhere. and its importance. So in relation to offshore oil and gas exploration and exploitation, protection of the environment is very important. And this is an example. The case was formally settled in 2016. So it was nearly 6 years of litigation involving governments, states within the United States, companies, foreign companies, US companies, local governments, and so on. Now, the second issue was Montara oil rig, which some of you may be familiar, and I have put a YouTube link here that you can watch about it. Now, after that happened, there was negotiation with Indonesia, between Australia and Indonesia. I think in 2018, there was a memorandum of understanding signed by Indonesia and Australia in relation to oil spill accidents like this. This issue was very important in Australia and resulted in change of policy, change of law, new legislation, inquiries, and was very important, and it is important. So, environmental issues in relation to exploration for and exploitation of oil and gas from the sea is very important, and it is subject of the Law of the Sea Convention, as we see in a moment, as well as other international treaties, customary international law, case law, domestic law, and so on. Now, environmental issues of offshore oil and gas production are subject of a number of articles in the Law of the Sea Convention. For example, Article 80 authorizes states to establish drilling installation with safety zone around them to protect them and to prevent accidents. Part 12 of the Law of the Sea Convention, Articles 192 to 237, are concerned with protection of the marine environment. Article 208 states that countries have to adopt laws, regulations in order to prevent, reduce, control pollution of the marine environment arising from or in connection with seabed activities and from artificial islands, installations, and structures under their jurisdiction. That's what they erect, for example, oil installations to exploit or explore oil and gas. And Article 194 particularly require the state parties to take measures to prevent, reduce, and control pollution from marine environment from offshore oil installations. Okay, the good news, I'll give you the good news that I'm almost finishing. So in about, I've got a couple of more slides and then we can, I'm happy to answer the questions. Now, as you can see, so far I discussed the position of the Law of the Sea Convention mainly, but there are many other international treaties about the environment, marine environment, and also relating to the sea. Those treaties are about maritime issues, they are about shipping, they are about fishing, they are about military uses of the sea, and so on. Now, what's happening now, we are in 2020, is that probably the Law of the Sea Convention, although it's, as I said, one of the most effective treaties in the world, may not be, maybe in some aspects, out of date. Technology has now improved, digital technology is now involved in the sea in relation to different uses of the sea, and therefore we need better, more effective international legal principles. Now, there was going to be a United Nations Ocean Conference in 2019 first, which didn't happen, and it was going to be in 2020, but it is now postponed due to COVID-19, not COVID 189, I mean COVID-19, sorry. So this conference, which was going to be co-hosted by Portugal and Kenya, following a United Nations General Assembly resolution, was going to focus on a range of ocean issues, including reducing marine pollution, protecting marine and coastal ecosystems, minimizing acidification, ending illegal and overfishing, respecting international law, sustainable use of ocean in relation to different uses. But it is now postponed, and probably I hope that this conference will produce mechanisms or maybe instruments for other complementary treaties, instruments to the law of the sea in relation to different aspects of the sea, including offshore oil and gas production, as well as other uses of the sea. Now, what is the future perspective of the law of the sea and offshore oil and gas production? Now, offshore oil and gas are carbohydrate resources, and as probably fossil fuel, you know that with the climate change, different countries are trying to reduce the use of oil and gas. Of course, oil and gas are used for other purposes than producing energy. Therefore, for the next 50 and so years, still we will see producing oil and gas from offshore resources. Now, other uses of the sea, for example, floating cities. Already there are cities or buildings built in, like Dubai in the United Arab Emirates and in other countries. Pollution, ocean pollution is becoming so significant and important, and also the use of the exploration of other minerals. Now, the seabed area, the bed of the ocean, you know that 2/3 of the earth is the sea, is ocean. And under the ocean, there are mountains, minerals, resources, soil, volcanoes, many other resources, facilities, things that they are there. And therefore, with the advance of technology, humans are certainly going to move there and to outer space. Now, future of international law and law, in my view, is on outer space law, and the seabed area. These are two important areas of future international law, and also digital use of the ocean, using data, modern technology in relation to the use of ocean. I think I should stop now and welcome questions and comments and give the floor to you and to others.
Okay. Thank you very much, Dr. Hussein. Okay, very well, ladies and gentlemen. Now we come to the question and answer sessions. Okay, I have one question from the chat column. I will share it. Okay, this is questions from Muhammad Shashwan. He asking about it is stated there that the resources, minerals, and any non-living resource administered by the International Seabed Authority. Therefore, if any of those resources was found there, how the International Seabed Authority administered that issue on who should entitled to reap the resource? That's the questions.
Good, and it is a very good question. Now, first of all, like as I said, in 1982, the law of the sea convention, those who adopted the law of the sea decided that the resources of these high seas under the ocean are common heritage of humankind, and the resources should be explored and exploited by authority of the seabed authority, like ISA. Now, this is a very good question, which then in 1982, probably states were not aware. If somebody would ask this question then from them, that probably they may have do something different. Now, the International Seabed Authority is not a big organization. As I said, it's a very small organization, has got an office, and some people are working there, about $20 million budget. What they don't administer, they're not companies like a small organization like ISA cannot really administer an issue like exploring oil and gas from the high seas. Companies can do, like BP, British Petroleum, or Australian BHP Bulletin. These are companies who easily pay $20 million fine, $20 billion. And these are countries who can organize, administer the exploration and exploitation of those resources. Now, what the authority does, and it does now, is that the authority issues licenses for big major oil companies or countries where oil companies are governmental companies, and then oil or gas or other mineral companies, and then those mineral companies do the job, administer the exploration and exploitation, and then the authority issues the license and probably regulates according to the law of the sea and international law, or observe the regulation or observe the application of international law and regulations in relation to the use of the sea.
Okay, Muhammad Shashwan, is there enough for you? Or should be there is another explanation for you? Okay, he said thank you. Okay, thank you very much, Dr. Hossein. I have noted several issues or several points from your presentations that regarding the events of technology developmental. Now human can reach the exploring and exploitations further in continental shelf until beyond 200 miles. And then I noted several point that regarding about the newest conference, UN Ocean Conference 2020. Unfortunately, it has been postponed regarding the pandemic of COVID-19, but it gives us new issues that is very interesting to be discussed in this lecture. Okay, dear participants, we have lots of topics that we can discuss in these discussions. Maybe you may raise your hand by pressing the raise hand button in your menu bar. maybe you can deliver it directly by yourself. Is there any questions? Okay, from Mr. Pulung Widihari Ananto.
Okay. Good afternoon, ladies and gentlemen, and also the participant of the summer course. Actually, I think first of all, I would like to say thank you for Mr. Hussein for the addressing some presentation. It's very enlightenment regarding about half the law of the sea itself. But I have some several questions, Professor. I think it's basic question in regard about the exploration and exploitation in the arena or in the international sea. As we know that based on the Convention on Clause 82 states, the arena or the seabed in the international sea is belong common heritage human mankind. But in other side, the developed country is always using the persistent objector principle to try to optimize and also monopolize this area. So I need your response. Thank you very much.
Good. Yeah. Look, as I said, and as you said, the area was decided to be the heritage of humankind, so belonging to everyone. However, industrial countries or developed countries, particularly the United States and some other major countries, they pushed for an agreement which is known as 1994 Agreement to Part 11 of the Law of the Sea Convention, which slightly adjusted the provisions, the original provisions of the Law of the Sea Convention. That means that now developing countries like and big major international corporations, they can get the license and produce resources from the area for any purposes. Now, one of the reason that United States of America did not ratify, like they attempted, but the Senate, who I think in the US, according to their legal system, they need 2/3 of the members of the Senate to ratify an international treaty. They didn't. One of the reasons was that they thought if we sign this treaty, particularly provisions in relation to the area, which is international seabed area, if United States argument by one of the Secretary of Defense, Donald Rumsfeld, during the Bush administration, George W. Bush administration, he argued that if United States signed the treaty and particularly provisions of the area, that would be a example or precedent for the outer space. And we might be, like the United States, may be pushed to enter into another treaty similar in relation to outer space. So that's how it is. It may not be fair, but that's how international relations work. Like powerful countries in relation to the high seas, in relation to the outer space, they have the technology, they have the science, and they have the power, and they go their own way.
Thank you very much for the explanations, Dr. Hussein. Is there any questions? Maybe you can raise your hand, because we have a lot of topics that we can discuss in these discussions. Dr. Hussein has studied that there is several countries that haven't ratificate this UNCLOS, but they have signed this ratification. And then for United States, it has signed the agreement, but has not been ratified. So, and then regarding about overlapping issues, overlapping legal regimes that brings a lot of legal issues, problems between those parties, those countries that involved in this overlapping law regimes. Is there any questions regarding these several issues? It's very fascinating, actually. Okay, I think there is enough. That's enough, Dr. Hossein. There is no questions from the participants, and I would like to close the question and answer sessions. Okay, very well, ladies and gentlemen. Finally, we come to the end of this general lecture. Regarding the lecture, Dr. Hossein has stated and has teach us about the United Nations Conventions on the Law of the Sea of 1982, and then there are several law issues that has been taught by him regarding environmental issues, and then the law regimes such as a territorial sea, and then until the seabed and subsoils regime. And then he has informed us about the newest conventions, the UN Ocean Conference 2020. We see that the environmental issues is bring up to this conference, because we know that in this last decades that the environmental issues is very has a human attentions of the all of the worlds. That's all for the conclusions. And then I would like to say thank you very much for our guest lecturer, Dr. Hossein Esmaili. We are very grateful you took the time out of your business schedule to address this lecture. I hope that in the next time or in the next opportunity, you may deliver the next or the other lecture. Lectures. Thank you very much, Dr. Hossein Esmaili. And then I will not forget to say thank you very much for the participants and then for your active participations. Hopefully the presentation will be beneficial for everybody. Thank you for attention. Good afternoon. Now I would like to return the time to the host, Gaffy. Sorry, Dr. Hossein. If you don't mind, there is another questions from the participants I have seen here. I just noticed in the chat column. Do you want to answer?
I can see the chat column. Which question you're talking about?
From Azadel Aureliano.
Yeah, okay, I can see. I have a question about the conflict between China and Indonesia regarding the sea territory in the Natuna Sea. The territory of Indonesian sea intersects with 9-line of China. What do you think about that? Okay, that's again a good question. Now, look, South China Sea has a special status. Now, China has some historical claims. According to the law of the Sea Convention 1982, historical claims are not a reason for sovereignty or jurisdiction or for claim of the sea. What you need is, as I discussed, like you can claim territorial sea, exclusive economic zone, and so on. Now, the different maritime zones that I explained, like I said, Indonesia, for example, can claim 12 nautical miles as the territorial sea, then 200 nautical miles as the exclusive economic zone, and so on. Every other country can do it, and countries can do that in relation to their islands. Like, for example, Australia has got a big island close to Indonesia called Christmas Island. And a lot of those boat people, asylum seekers, when they used to come to Australia, they would come to Christmas Island. Now, around Christmas Island, Australia has the same jurisdiction, the same sovereignty, like 12 nautical miles is part of Australian waters around the island, and then 200 nautical miles and so on. Now, what China did has done in recent years is that China is kind of building artificial islands, or there have been some reefs which are not islands, just stones and rocks there. And China is trying to develop them and make them islands and then claim territorial seas and exclusive economic zones around those islands. And that overlaps with continental shelf and maritime zones of the Philippines, Vietnam, Malaysia, and you're now telling me Indonesia as well. And that's something that also there was an arbitration case where the arbitration award decided against China in favor of the Philippines, and it is now a major international issue. The South China Sea is not only important for Indonesia, the Philippines, Vietnam, Brunei, Dar es Salaam, and other countries. It is also important for Australia, for other countries, because it's an international trade route. So that issue still is an issue. And then, as I said, because in the 9-dash area, China is developing islands and claiming that they are islands, and China has maritime zones around those islands. Whereas under the law of the sea and under international law, there are exclusive economic zones around islands, but not artificial islands. Now, other countries like the Philippines, Malaysia, Vietnam, United States, most other countries believe that those islands in the area, they're not islands, they are reefs, and China has made them artificial islands, so there is no territorial claims. And that probably is the position of Indonesia, whereas China is claiming more or less maritime zones around those areas, and that overlap with other countries. Now, if it was real islands, like if there is such an issue between, let's say, Indonesia and Malaysia in relation to a real island, then the law of the sea and international law has provisions how to settle the dispute and how, when the exclusive economic zone or the continental shelf overlap, we do have provisions at the law of the sea convention, and we do have also a number of cases, at least 2 cases. One of them is Black Sea case, International Court of Justice, which provides rules and regulations how to settle disputes when the exclusive economic zones or the continental shelves of 2 or more countries overlap.
Okay, thank you very much, Dr. Hossein. And then there's another question from Alia Akila in the chat column. It is about accidental pollutions. Who will be responsible if there's oil spillage in international waters? Who will clean it up?
Okay, that's a good question too, because now oil spill happens either from ship vessels or from oil installations. Okay, now ships or vessels under international law, they fly with the flag of a country or they registered somewhere. So therefore, if the vessel is flying with Australian flag or with other flag, or where they are registered, those countries are responsible for protection of the environment, and there are provisions in the law of the sea convention on that issue. However, if it is oil installations, again, the same thing, like oil installations are erected, let's say by BP, which is British Petroleum, and it's registered somewhere. It's registered with the UK or could be United States. So those countries are responsible. So although you're right, the high seas is for everyone, but then oil spill is either by vessels, by international shipping, or it's from oil rigs from oil platforms, and and those and those ships, vessels, and platforms are registered with the country. And also, in relation to exploring and exploiting the resources of the area, countries get license from the international authority, and then they have to follow environmental assessment regulations, and they're responsible.
Okay, thank you very much, Dr. Hossein. Okay, we received another questions in the chat column. Okay, from Adlina Hisham. What is the difference between ratify and signed agreement? And if the agreement has been ratified, does the law need to be consistent with it? And because we see that in UNCLOS 1982, there is several countries that haven't signed these conventions. The time is
Okay.
yours.
Okay, good. That's another good question. Look, generally, signing a treaty is done by the executive, by the government. Let's say, for example, Foreign Minister of Australia or Indonesia or Secretary of State of the United States goes to an international conference or goes to the United Nations and sign a treaty. That means, hey, we are happy, we are ready to join this treaty. However, because in most countries there are separation between the executive and the parliament, or the legislation or the legislative power of the government, then that signature should be ratified by that country. Like in Australia, treaties are signed by the governments, but then they have to be ratified here either by the cabinet or by the parliament. In the United States, the international treaties have to, when they are signed by the executive, then they have to be ratified by the US Congress and the Senate particularly in order to become law. Now, in Indonesia, I don't know exactly, I'm sure many people here know better than me, there must be provisions either in your constitution or in your legislation which provides what should be done. But signing is just willingness by the executive of a country to join a treaty. But then that treaty should go to the parliament or the cabinet or other parts of the government. In some countries could be the king, for example, to be ratified and then become part of law of that country, probably. Like in Australia, Australian government signs a treaty, then they ratify it. But in order to become law, it must become part of a legislation by the parliament, federal parliament of Australia. So that's the difference between signing a treaty and ratifying a treaty. Now, more details about signing, reservation, ratifying, implementing international treaties can be found in the Vienna Convention on the Law of Treaties, which provides how treaties should be concluded, how to be signed, how to be ratified, and how to be implemented.
Okay, thank you very much, Dr. Hussein. Is there any question for the other participants? We have received there are 4 questions, and then is there any questions from all of you? Okay, I think it's enough. There is no more questions. I have checked in the chat column. Okay, thank you very much, Dr. Hossein Ismaili, for your time. You have you have delivered your lecture in this afternoon. I will close these sessions and I will return the floor to the host, Gaffy. Gaffy, time is yours.
Okay, thank you so much, the Honorable Guest Lecturer, Associate Professor Hussein Asmili, LLB, LLM, PhD, for the general lecture for today, and also Mrs. Andika Miraja for delivering the event today. Now we will take a break for an hour. For all the participants, please be ready at 1 p.m. Indonesian time, or just set the timer for an hour and make sure to come back here on time for the next agenda. Thank you, and we'll see you later.
Dr. Hossein, before we end this, or you may leave this Zoom, we would like to take a picture before you leave these meetings.
Sure, and I would
Okay.
like also to thank you and everyone. And it was great to talk to you in Indonesia.
Okay. Ladies and gentlemen, we would like to take a picture. Please turn on your camera. This is for our document. Okay. On my sign, 1, 2, 3. Okay. To the next page. 1, 2, 3. To the next slide. 1, 2, 3. Thank you very much, Dr. Hussein. I hope you are well in these unprecedented times, and we will see you in another opportunities. Thank you very much.
My pleasure. Thank you very much.
Okay, dear all fellow participants, you may take a break right now, and if you want to maybe to keep joining with us, you may turn off your camera, and please don't forget in 1 p.m. we have another agenda, or maybe in 2 p.m. in Selangor time. Thank you very much and good afternoon.
For all the participants, please don't forget to absent your presence for today. Thank you.